Welcome to a new show here on Medfield TV called Simply Legal. I'm Geraldine Warren, a longtime Medfield resident and a practicing attorney here in Medfield, specializing in estate planning and elder law. I will be your host for this program, and I would like to mention that if there is an area of the law that you would like to hear about, please email me at gwarren@warrenlawllc.com. Today I have with me Colleen Canali from the Divorce Collaborative. She will be discussing different divorce processes, ways to avoid a longer process through a prenup, and also the Alimony Reform Act of 2011. Welcome, Colleen. Would you like to tell the community a little bit about yourself before we begin?
Sure. Thank you for having me. My name is Colleen Canali, and I'm an attorney and a mediator at the Divorce Collaborative in Franklin, Massachusetts, and my firm concentrates on divorce and family law matters.
Colleen, do you want to start with the different divorce processes that there are available to people?
Sure. There are several different divorce process options available to couples when they decide to divorce. The first process option is mediation, and my firm does both process options. We are able to offer our clients the choices of which divorce process option works best for them. With mediation, the couple chooses to hire one neutral mediator.
Are there benefits to having the mediation?
There are a number of benefits. First of all, mediation is a confidential process. It is a private process where the parties will sit down with the neutral third-party mediator, and they're able to work through the various issues in their divorce: care and custody of minor children, division of assets, alimony and child support issues, in a private office as opposed to in a courtroom where it's public. And a lot of couples find that very attractive. As well, mediation generally is more cost-effective than expensive divorce litigation. It's generally a shorter process. For example, in a contested divorce-based case, the court puts it on a 14-month track, whereas mediation, I would say average mediations can conclude with between 4 and 6 months.
Would you say that more people are going toward the mediation route as opposed to the court-based process?
From what I have seen, yes. I've been practicing 12 years now, and I definitely see a trend towards mediation. It's also a more amicable process. It's not of course, right in every single divorce case. Generally, what I do is when I meet with clients, I go over the different process options, and then the client chooses which process option is best for them.
In your opinion, does mediation, though, work in many cases as opposed to having to go through the court-based?
It does. It works in a wide variety of cases, even in contested cases where parties seemingly cannot agree on various items. The other thing that is beneficial about mediation is I certainly take a collaborative approach. So I have done mediations, for example, where we've brought in financial advisors, and the financial advisors have met with the parties to assist us with the division of assets and some more complex financial matters. I've also brought in divorce coaches and parent coordinators to sit with parties to help them work through parenting plans. And these are in highly contested cases where at the outset we think mediation may not be appropriate, but really when you break down the issues, mediation can be successful even in contested cases.
Yeah, it seems like with the collaborative effort that it could work. So do you think that a lot of times when there's children involved and visitation and, you know, as far as child support goes, is that the time that there's a lot of issues that come up with regards to whether you go with mediation versus the court-based?
It really depends on a case-by-case basis. Some couples have difficulties agreeing on what is in the best interest of their minor children. Other couples have issues with agreeing what is a fair and equitable division of their marital assets. And then some couples, unfortunately, have disputes in both areas. But even if couples have disputes in one or both of those areas, a mediation can certainly help them through the process.
If mediation doesn't end up working, and even though you might have said this is a route that you might want to think about, and they decide that it's not going to work because they aren't having a meeting of the minds as with regards to mediation, then you do the court-based, is that right?
Correct. In a court-based case, one party generally initiates the divorce complaint, files against the other party, and it is a lawsuit where one party is suing the other person for divorce. And just like any lawsuit, generally most parties have attorneys. and it is an adversarial process, and it goes through the court system. And the court, as I mentioned a few moments ago, does put it on a 14-month track. Some cases do end up resolving before the 14 months, but that's generally about the average of when most cases will resolve. In a court-based case, generally the lawyers in the court schedule dictate how the case is going to go, and the couple often loses some control over the process.
Are there also a lot of filing fees involved with the court-based in addition to the attorney fees, or?
There are filing fees under both process options, under mediation and under a court-based case.
So that wouldn't be a determination whether
No,
they're doing, okay.
No. Generally, what you're saving on a mediation as opposed to a court-based case is you're hiring one professional as opposed to both hiring two attorneys. The other thing is in a court-based case, oftentimes you're paying your respective attorneys to be in court all day, and you may be able to get in to see the judge for half an hour if you're lucky.
Yeah, and you said the timeline is about 14 months. Can you walk us through like what that would entail as far as the time? Like, do they file and then they have to wait X amount of time?
Certainly, the beginning of the court-based case starts with the filing, and then the defendant is served the divorce complaint. The defendant has 20 days to answer the divorce complaint. And then after that period of time in Massachusetts, there's a 6-month waiting period before the court can actually enter a divorce. That's a minimum requirement.
And can you give us the reason for that requirement? Is it for any reason why they chose a 6-month?
It has to do with public policy.
Okay.
And what they wanted to avoid, my understanding at least from what they wanted to avoid, was folks getting into arguments and running down to the courthouse and filing for divorce. The Commonwealth wants to encourage and support marriage.
Mm-hmm. So it's sort of a breathing time for the two parties.
Correct.
Okay.
Correct.
And after the 6 months, what?
Well, within that 6-month period, there has to be an exchange of financial documents. There's minimum financial document disclosures, for example, 3 years bank statements, 3 years income taxes, recent pay stubs. So there's a number of things that have to be accomplished within that period of time. And some couples have to go to court on what we call temporary orders. Because a divorce case can pend for so long, oftentimes parties do need to get into court so that there's some temporary resolution to what the care and custody of the minor children is going to look like, as well as what the support piece is going to look like as well while the divorce is pending.
Now, if they did end up going court-based, where would they file if they lived here in the Norfolk County?
The Norfolk County Probate and Family Court is located in Canton.
Okay, and that's new. Canton, it used to be in Dedham, is that correct? And then
It was in Dedham, and don't quote me on this, I believe it moved around 2002, maybe 2003, in that area. It moved over to Canton.
Okay, and then I had mentioned in the beginning that there is some people choose a prenup. Can you just generally go over when you see that as an advantage to couples before they get married entering into a prenuptial agreement? Or
I've also seen an increase in the number of couples entering into prenuptial agreements. I think there was a misconception that it was reserved only for the wealthy, and that's not necessarily true. I do see prenuptial agreements when one party is trying to protect a business, for example, a family business, or an inheritance that they may have received. But in a whole other subset of cases is we have a lot of second marriages, third marriages now. So in those types of situations, you may have a couple who's getting married a little bit later in life who have adult children from a prior marriage, and their concern is they want to protect their assets that they would like to leave to their children as opposed to their new spouse that they're marrying. So we have my firm's
provisions for that as well?
We do have provisions for that, not only to protect assets in the event of a divorce, but also in the event of a death.
Yeah, I think that I would agree with you. Just in my own practice, I have seen people asking about prenuptial agreements, basically because their children are getting married and they're wondering about their inheritance and stuff, and then I would refer them to a family law attorney. The other thing I mentioned in the beginning was the Reform Act, the Alimony Reform Act of 2011. Do you want to maybe tell all of us a little bit about that?
Sure. The Alimony Reform Act had been in the works for a number of years. Under the old alimony system, it was somewhat antiquated, and you had different results depending on the court you were in, the judge you had. Judges had wide discretion under the old alimony as far as the amount of the order and as far as the duration of the order. The new Alimony Reform Act has increased predictability in alimony orders, as well as it has given practitioners a guideline on how to assist our clients and advise our clients in crafting separation agreements with respect to the alimony provisions. For example, under the new Alimony Reform Act, alimony orders are generally between 30 and 35% of the differences in the parties' gross incomes. So that guideline has certainly assisted practitioners in running alimony calculations. In addition, depending on the length of the marriage, we now understand what the duration of the alimony is going to be. For example, on a long-term marriage over 20 years, the alimony duration can be a number of years, and there is a presumption, however, that in a long-term marriage that alimony would end at the payor's Social Security retirement age, which is currently age 66.
Is there discretion with the court where there's a long-term marriage over 20 years? Can they still, let's say it was prior to the Alimony Reform Act and someone had entered into a permanent agreement, is there a way of changing that with the new Alimony Reform Act?
There is. If the payor has already reached Social Security retirement age as of March 2013, the payor is able to file a complaint for modification with the court asking that the duration of the alimony order be modified.
Now, if it's a short-term marriage, what does the Alimony Reform Act do with regards to that? Are there any limits, like if a marriage is 5 years versus 15 years? Do they have any set guidelines?
There are. It is a tiered approach. So, for example, in a marriage under 5 years, it is capped at the 50% of the length of the marriage.
And then 15 years is, what did you say, like if it was 15 years?
15 years is 80% of the
80%?
length of the marriage. So it is a tiered approach depending on how long the marriage
Right. So that the public, do you know what the public policy was behind the having the Alimony Reform Act of 2011? Was it just for a fairness doctrine, or?
I think it was a combination of fairness as well as reflecting the times that we're in. One of the provisions of the Alimony Reform Act that I didn't mention before is the Cohabitation Clause. There's now a Cohabitation Clause in the new Alimony Reform Act. And the Cohabitation Clause essentially states that if the recipient is in a substantial dating relationship for more than 3 months, that alimony can be modified.
Oh, that's interesting.
Under the old system, it didn't necessarily matter if the recipient was cohabitating with another. What mattered was whether or not the recipient actually got married. So you had a whole group of individuals who intentionally would not get remarried because they knew that their alimony from their first spouse would actually end. And so now that has changed, and I think a lot of folks believe that that is a lot more fair.
I do.
Certainly.
I agree. I hadn't thought of that. That's very interesting. Is there any final thoughts that you have that you would want to share with the community with regards to the different processes, or with prenups or anything before we end?
I would just encourage clients who are about to enter into a marriage to, especially if it's a second or third marriage and there are adult children involved, to consult and have a consultation with an attorney about their different options. And with respect to couples who do find themselves facing a divorce, educate yourself on the different process options available and choose which process works best for you, your children, and your family.
Thank you, Colleen.
Thank you for having me.
Well, that ends the first segment of Simply Law. However, I would like to give an update on my program, the Affordable Care Act, which I filmed last month. Since the filming, the administration has put a delay on Title I, which was going to provide the federal-based health option and the shop exchange program for small businesses. That will be delayed until 2015. It currently was supposed to go into effect in 2014, and at the time that we filmed, I mentioned that the application would be up for the pool in October of this year. However, the administration has decided that it's not prepared to start with that program, and it has been delayed for at least a year. So I did want to give that update to the community, and again, thank you for joining us today.
Production support provided by Medfield.tv. Access to our community.
I'm Roberta Lynch, and you're watching Medfield.tv.